know anything about your case. The only thing I know is what you're charged with. I do not, and I'm not allowed to do a pre-jury trial where I hear everything and make decisions, and then people can. So for this case, there were some officer records or something?
Yes.
And state?
Time for a legal reality check. Judges aren't backstage directors calling all the shots before the curtain rises. What you're about to hear is a masterclass in courtroom limits, delivered with Judge Boyd's signature blend of clarity and
We're not going to sponsor that officer's witness.
All right. But the question is whether you are going to sponsor the officer or not. Did that officer have any?
Yes, he did. She did.
So then the question becomes whether or not the defense is just going to accept that that officer is not going to be called as a witness, because maybe they want to call the officer as a witness. I don't know. So where are we on that? Have you all conferred over that?
Well, not over that. I mean, he's not somebody I would want to call with.
All right. So then do you need the records then? Since they say they're not sponsoring him as a witness, they're not going to call him.
That's correct. Now, because of that, there is a secondary officer that they intend to go forward with, who didn't make the arrest, who didn't make the stop. And I've got some motions I'd like to file on that.
Well, why? I mean, I don't understand why that hasn't been done. What motions need to be filed on that?
Well, I don't know that that officer can sponsor this other officer's stop and video when she wasn't even there.
I mean, well, that'll be something for you to take up at trial and see whether or not, and I'll make a ruling on whether or not that officer is allowed to testify. But whether or not that officer is allowed to testify, I can't make that decision unless you're actually in trial, because I don't know what the state's evidence is going to be. I don't know if that officer has any ties to this case whatsoever, tangentially or not. So that would be something that would have to be taken up at trial, whether or not that witness is relevant.
Well, there is an issue on the stop itself. But it is a video that was made by the officer that they're not going to.
And here's your courtroom cheat code. Just because the prosecution drops a witness doesn't mean the defense can't scoop them up. Think of it like legal dodgeball. Any player still in bounds can be
sponsor.
All right. So what I'm saying is this, and I want everybody to hear me clearly to make sure that I'm communicating what I'm trying to say to you.
Yeah.
In a jury trial, witnesses will be called. I don't know anything about your case. The only thing I know is what you're charged with. I do not, and I'm not allowed to do a pre-jury trial where I hear everything and make decisions, and then people can then have a trial. So what will end up happening is the state will call witnesses. If there's a witness that the state intends to call and the defense thinks that that witness is not relevant, then I will make a ruling. If I determine that witness is not relevant, then guess what? That witness won't testify. For example, on your case, I know nothing about your case. Hopefully, Ms. Abrams knows nothing about your case. So if the state were to decide to call Ms. Abrams as a witness in this case that she knows nothing about, then you know what your attorney would probably do? Your attorney would probably say, Your Honor, I'm object to Ms. Abrams as a witness. She knows nothing about this case. Then you know what I will say? Ladies and gentlemen of the jury, if you'll step outside, we're going to have a hearing outside your presence. And then I will have your attorney to question the witness. He'll probably say, Ms. Abrams, were you at this scene? No, I was not. Do you know anything about this case? No, I don't know anything about this case. Then I will turn to the state and I will say, State.
Judges can't predict the future. They need evidence, not hypotheticals. If you've ever screamed, why won't the judge just decide already? This is why. It's not just fair, it's foundation.
How is this witness relevant? And then if they tell me, well, she doesn't know anything, then guess what I will say? This witness is not allowed to testify. Ms. Abrams will step down. The jury will come back in. I will give the jury instructions and I will say, Ms. Abrams, the witness who was called, you're disregard any testimony that you've heard from her. It's as though she never even appeared. But I won't know anything about this case or not unless we're in a jury trial.
Well, then we do have some motion and limine issues on the case.
with the motion in limines, the way that happens, unless there is some legal reason that it appears that testimony or something cannot be heard, then I can make a ruling on it. But I can't grant motion in limines when I know nothing about the case. For example, the only way that I will be able to grant a motion in limine is, this is a DWI. Let's say somebody's saying you committed a murder also, right? That is unrelated to this DWI. With that, I can say that is not coming in whatsoever. But usually with motion in limines, it's different things where the attorney does not want certain things brought before the jury. And what I'll tell everybody is I'll say, look, state or defense, if the state has a motion in limine, I'll say, if you're going to get into the fact that she cut down Auburn's oak tree or whatever, I'll be like, y'all need to approach before you question that witness about that. And then the jury will go outside and then we'll talk about it. And I'll say, okay, what does her poisoning or cutting down the tree in Auburn have to do with this case? And again, if it has nothing to do with the case, I'll be like, it's not coming in. Or if I find that it's more prejudicial than probative until I know what's going on with the case. Because the only thing I know about your case is what you're charged with. I don't know any facts of the case whatsoever. I don't know. The only way I know about blood draws or whether was there a blood draw or not is because of discovery issues that were asked for. So that's where we are.
Well, Judge, I do believe I have a right to file a motion.
Courtroom drama. Imagine being yanked from the witness stand mid-sentence and told your testimony never existed. If your relevance doesn't check out, you're legally vaporized.
To suppress the blood draw, I have the
but has that been
file
filed?
a motion to suppress the video.
Has it been filed?
I'm going to file it now, but this is the first notice that I received that they're not going to use that witness at all.
Okay.
So I'm asking you to give me a 2801 pretrial hearing.
Well, you all need to file those and file it today, and it'll be heard today. Thank you.
I don't know that I can file it today.
This case has been going on since July 2024, and I know Ms. Cotner is ready for this case to be concluded, and this case is going to be concluded, so it needs to be filed today. We've been here forever on this case.
Well,
So,
Judge,
file the
this
motion.
is the state's delay, not mine.
Mhm.
You understand that?
I do understand that. And what I'm telling you is motions need to be filed, and those motions need to be filed today. I don't know how many other ways I can say it.
Right.
Your motion needs to be filed today.
I will file it today, but it's what I heard you say you would hear it today.
File your motion. State, have your witnesses here. Discuss, confer.
Okay. Very good. So, is Mr. Soriano excused?
No, you're supposed to be conferring.
Well, assuming we don't do a video,
Here comes the Legal Balancing Act, Rule 403. Judges weigh evidence like it's on trial itself. If it confuses more than it clarifies, it's out. And yes, we're all still wondering, who cut down Auburn's oak tree?
plea on his case.
You all need to confer. And then once you've conferred, then you can approach attorneys. You need to confer with the state before you approach the court.
This case has been dragging longer than your favorite Netflix show's final season. The judge isn't just enforcing rules. He's fighting courtroom fatigue. Deadlines aren't suggestions. They're sacred.